Good morning or good afternoon. I'm going to talk about the argument against disciplining or firing Miss Turner. So in introduction, it says that the legal context of Miss Turner's predicament in the state of Florida and the moral ramifications of the school district's employees' policies must be determined in the case of Miss Turner, this who has discipline for verbal outburst and the email that followed. In the context that Ms. Turner has the right to advancement and should not inflict a penalty or fired after carefully weighing the state and federal laws, court decisions, and moral principles. So Ms. Turner got hired for a position that she wanted. Somebody younger with less experience got hired for the position, and instead of going and talking to somebody, she sent an outburst email to another teacher and accidentally sent the email to the principal also saying that she was wrongfully denied the promotion. So when we're talking about Florida, Florida is an at-will employment state. Business are free to fire workers for any legitimate reason when determining whether Ms. Turner's actions call for disciplinary action. It is necessary to consider the protections provided by both federal and state statutes. One, the First Amendment rights. Public servants are eligible to free speech or issues of public interest under the First Amendment of the U.S. Constitution. This clause might protect Ms. Turner if her outburst was related to her job or working environment. Number two, Florida statute. The law prohibits the employees from discriminating workers against race, color, religion, sex, national origin, age, handicap, or marital status under the Florida statute 760.10. Using discipline if Ms. Turner's outburst is it is definitely due to any of these actions, especially if she belongs to a protected class, then she might be engaging in the discriminatory behavior. Number three, the whistleblower protection. Ms. Turner's protection from the reprisals under the whistleblower law if she remarks about unlawful activity or misbehavior within the school district were genuinely. So as defined by the Florida statute 112.3187. Considering this factor, Ms. Turner's rights are both federal and state law may be violated if terminated or disciplined without conducting a comprehensive inquiry of her accusations. Ethical missteps in hiring practices. So the school district's hiring practice may also come under scrutiny regarding their legal liability. Lack of proper vetting. The school system may be accountable for careless hiring practices if they hire employees who might have contributed to the pernicious work environment before Ms. Turner's outburst and did not perform sufficient reference background check. Remember, the teacher that got hired has only 8 years of experience, contrary to the 30 years of Ms. Turner's experience. Number two, failure to address workplace culture. It is essential duty of the school district to provide a secure and encouraging work environment for its staff. They might be accountable for fostering an atmosphere that encourage such outbursts. If they disregarded complaints about harassment or workplace culture before Ms. Turner's event. In addition to harming the administration's reputations, these errors put at risk the legal action for failing to uphold proper employment practices and working conditions. Legal precedents for consideration. Ms. Turner should consider her opinion to legal precedents as she evaluates her opinion. One, I'm going to give some examples like Pickering versus the Board of Education, 1968. This historic case protected public employees' freedom to express their opinions on issues in public interest without fear of reprisal by establishing that they did not give up their First Amendment rights when they accepted the position with a government agency. Number two, Grassetti versus Ceballos, 2006. Even while it limited the rights of the public officials speaking during their official business, rather than as a private citizen, this ruling emphasizes the importance of context in determining whether protect speech. Number three, Burlington Northern versus Santa Fe versus Burlington Northern and Santa Fe Railway Company versus White, 2006. By establishing any unfavorable action taken against an employee who practices in protected behavior may give a rise to a lawsuit. In this case, increased protections against retaliation under Title 5, verse 6 of the Civil Rights. These incidents provide a solid foundation for Ms. Turner's potential claims against the educational system. Should she consider to pursue legal action following any disciplinary measures imposed against her? In conclusion, it is evident from Florida employment laws and permanent court decisions pertaining to free speech and workplace against that Ms. Turner should not be disciplined or fired for her verbal outbursts and subsequent email exchange if those actions were motivated by justifiable worries about her working conditions or wrongdoing within the school district. The district's problems are more difficult by the unethical employment practices, which also draw attention to its responsibilities based on their rights as an employee standing for herself and others at work. I firmly believe that Ms. Turner's ought to be protected from disciplinary action and given the opportunity to advance. Thank you very much.